Has the ADA accommodation process changed in light of COVID-19 related issues?
Generally, the process has not changed, but the assumptions underlying a lot of the accommodation decisions we make are changing. So adhering to the process is that much more critical. The ADA has always been and always will be a matter of moving targets. Accommodations are going to vary based on job duties, changing technology, and the changing overall work environment. These are influencers we have all experienced during the pandemic. A good place to begin understanding the accommodation processes is to explore what's covered and isn't under the ADA in times of COVID-19. What's not covered? Start with age. An employee's age alone and their potential for increased risk of adverse effects from COVID is not a disability legally requiring accommodation on the part of the employer. Employees who are caretakers for vulnerable family members are also not entitled to ADA accommodations. What is covered? An employee with a medical condition that places them at perhaps greater risk, say, someone who has pregnancy complications or someone with an immunocompromised disorder are covered. And many state laws do require an employer to provide reasonable accommodation in times of pregnancy. Employers need to think about state law requirements as well. Let's not forget about mental illnesses and the fact that many employees with a pre-existing or even undiagnosed mental illness or disorder that is exacerbated by isolation, fears, and grief from the pandemic may be covered. Incidences of depression and anxiety disorder are surging. A new concept we're just learning about is termed long-haul COVID. This is a prolonged manifestation of various symptoms and limitations from having contracted COVID-19. That impairment may require accommodations. And finally, there are employees with pre-existing conditions which are worsened by the use of masks as required by the employer or local governments. For example, certain persons with acute asthma may have difficulty performing some functions of the position while complying with the employer's mask requirement and may request a reasonable accommodation. But that doesn't necessarily mean compromising safety. Employers are facing challenging questions related to employee accommodation requests. These include shifts in types of accommodations, job restructuring, medical qualification standards, questions over requiring vaccines, and new areas of confidentiality. It's a brave new world for ADA accommodations. Please, remember to consult your Littler attorney if you need or are seeking guidance on these or related pandemic or return to the workplace issues.